I have extremely good news for the Second Amendment community. Contrary to media headlines out of the political elites in the state of New York, this decision in a case called Handbook versus Bruen, which is the first challenge that I'm aware of that actually has gone to a court decision involving New York's new insane, crazy gun laws that they passed after Bruen, is a very good decision for the Second Amendment community. Although the case was dismissed, and we'll talk about that, the decision and the precedent that it has set is devastating to New York. And anybody that tells you that's not true did not read the 74-page decision, or they don't understand how constitutional law works. We're going to get into this in just one moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're really trying to build this channel out, so we really would appreciate if you could subscribe and get other people to subscribe so we can continue to spread the word about the importance of the right to keep and bear arms here in America. Okay, folks. This is really big news. I wanted to shoot this video a bit earlier. I couldn't do it because I had some media appearances this morning on the radio, and that took up a lot of time, and this decision did not come out until late yesterday. But this is a very big decision you may have seen references to, although probably the references you're seeing are giving you false impressions. Okay, here's the bottom line. HJLPP versus Bruen was decided by the U.S. Supreme Court in June. You remember that. A bunch of states, specifically New York and California, raced to the legislative chambers to try to pass crazy gun control law because they were angry and bitter that they got slapped around by the United States Supreme Court, which is exactly what happened, by the way. So specifically the state of New York, which got literally beat up by the United States Supreme Court in HJLPP versus Bruen, was clearly very bitter at that terrible loss, which anyone who understood constitutional law would have expected. But New York refused to believe in reality of the Second Amendment right to keep and bear arms and the fact it's actually in the Constitution. They never gave it respect. They thought it was a privilege and not a right. So what did New York do? We all talked about this on the channel. They went out there and they passed a bunch of crazy, insane gun laws. Some of the things they did is they said that before you can get a carry license, we get to look at your social media accounts going back 3 years. We also imposed a good moral character requirement, which we have to make sure you have good moral character before you carry a gun. They also defined basically the entire state of New York as a quote-unquote sensitive place. And if you've been watching this channel from the start, you know that when you hear the word sensitive places, it is a euphemism for gun-free zone. And I told you way before the Bruen decision was going to be decided, that is exactly where the anti-gun community would go, and that's exactly where they're trying to go, and that's where they went in New York, but it's not going to work, and we're going to talk about that why in just 1 second. Okay, so basically New York passed all these crazy laws, training requirements, all this other stuff. Basically, as I saw it, they threw a hissy fit, like a little child that got angry when you scolded them, and they get all angry about stuff. And that's what New York really is here. They're a little child having a hissy fit. They passed all these gun control laws and said, see, take that, U.S. Supreme Court. But I explained in many things, including in my most recent article in the Harvard Journal of Law and Public Policy, which I'll post down below, which goes through what New York did and why it's not going to work. Guess what happened? So a series of plaintiffs, including Gun Owners of America and a man named Ivan Antonuk, they brought a lawsuit claiming that the new gun control laws in New York were unconstitutional. And we now have the first federal court decision from a federal judge who was appointed to the bench, by the way, by George W. Bush. That's Bush II, not his father, appointed to the federal bench. And what did he decide? Well, here's what you're going to hear in the headlines. What you will hear in the headlines, including by PR statements from New York State government officials, is that this was a case that New York State won. And they are correct, technically. What I mean by that is, in the 74-page decision by the judge in New York, he did say that the plaintiffs who brought the lawsuit lacked standing. Now, what a lack of standing means is that the plaintiffs did not allege all the things they needed to allege to be in federal court, because federal courts are special courts. You can only get into federal court if you meet a certain specified criteria, one of which is you have to have federal court standing to show that you are the proper person to bring the lawsuit. Random people can't bring random lawsuits. They have to, for example, be the one that's specifically injured in fact, and therefore they're the ones that have to sue to say, hey, I'm the one being hurt by this. I'm the one being injured by this, so therefore I have the right under the Constitution to go to federal court and get my constitutional rights vindicated. So what happened here is the court specifically said that the plaintiffs lacked standing the way the complaint was framed and the way they testified at the preliminary injunction hearing, and therefore New York wins this particular case. Now that is what you hear all about, that New York won, New York won, New York won. But let me tell you how you read this and what you really see when you read this as a constitutional lawyer. Now, let me start here. If you turn to page 53 of the decision is where the good stuff is. This is the stuff from page 53 to 74 that New York State wants to bury in the sands of time. But they can't. Why is that? Because all these constitutional lawyers, myself included, and I'm sure everyone that's interested in bringing a lawsuit against New York challenging these new gun control laws is going to read it. And guess what it says? In these pages here, it essentially says that the New York gun control laws are all unconstitutional. In fact, I'm going to read what I consider to be the money line, and then we're going to break it down more specifically in just a second. Here is what the judge said. Tell me if this sounds like a victory for New York. Quote, while pursuing the laudable goal of public safety and in an attempt to curb ever-increasing mass shootings, the New York State legislature has generated an unconstitutional statute. Let me read that again. The New York State legislature has generated an unconstitutional statute in CCIA, the name of the statute that New York passed, all that craziness. Court continues. This is not me, this is the court. In its 8-day haste to pass a legislative response to the Supreme Court's decision in NYSERPA versus Bruin, which reads less like a measured response than a wish list of exercise inhibiting restrictions glued together by a severability clause in case some of the more fanciful restrictions were struck down, the New York State legislature forgot 4 important words other than self-defense. Now, the bottom line is this. This court decision specifically says that the state of New York enacted an unconstitutional set of laws. So the court just basically said that he would strike down all these New York gun control laws, or at least most of them as I read this, except in this case, because the plaintiffs lack standing, they're not allowed to come to federal court. Because they're not allowed to come to federal court, I, the judge, don't have the authority to actually do this because I can only authoritatively act if I've got proper parties in front of me, and I don't have that. Nevertheless, I'm going to go ahead and talk about what I see this case being, because it's possible that the plaintiffs could appeal and then be deemed by the Court of Appeals to have standing, and I don't want to waste my time and do this twice. So I'm going to tell you what my opinion is if the plaintiffs had standing. And he basically says that all these gun control laws in New York are unconstitutional under the Second Amendment and NYSERPA. So let's go through some of these things specifically. So to begin, I want to break this opinion down because I know a lot of lawyers out there watch this channel. I know a lot of people watch this channel. A lot of people in New York probably watch this channel. And I want to give you the information you need so you can get this right. To begin with, the court said that the gun control laws passed by New York all implicate the Second Amendment right to keep and bear arms, which means it's a Second Amendment case. So yes, it is. And why did he say that? First of all, because the plaintiffs are obviously part of the people in the text of the right of the people to keep and bear arms. So because the people are implicated, the people are there under the Second Amendment. Number 2 is, he says, obviously carrying handguns falls well within the definition of arms, as in the right to keep and bear arms in the Second Amendment, and therefore discussing carrying a handgun in public for self-defense is clearly part of the arms. So you have the people satisfied, the arms satisfied, and then the judge goes on and says, and they're trying to regulate people carrying handguns in public, and therefore that activity, again, touches on the Second Amendment and therefore potentially violates the Second Amendment. At which point he says, now let's continue down and look specifically at these restrictions on the right to keep and bear arms to see if they can be justified as a matter of constitutional law, which by and large the judge essentially said, no, they can't. Now, the reason why it's so important to understand that this implicates the Second Amendment is because it triggers something that the Supreme Court said, that when conduct or law or regulation touches fingers with, meaning impacts the right to keep and bear arms of an American citizen, that means that the burden of proof, I repeat, the burden of proof to demonstrating the legality and the constitutionality of that law or restriction shifts to the government to prove that there is somehow this is constitutional. And one of the ways they are allowed to do that, if not the only way basically, is by showing that there are historical analogs to the law they're trying to justify. So here, the court says, because of this, New York State has the burden of proof. And if they can't meet the burden, it's game over. The Second Amendment plaintiff prevails and the government loses and the gun laws go away. So the judge says the government bears the burden to show that there's historical analogs for everything that New York wants to require gun owners to do. So that was the standard. He said, let's see. And then he says, let's see if New York did their job. Let's see how it goes. Once we now know the government has to show a historical analog to justify the restrictions that they're trying to prop up and justify as constitutional, we then have to ask ourselves, and the judge asked the right question, what is the relevant time period? Now, this is a topic that I think the answer is clear on. The answer is 1791, but we're going to talk about some of the constitutional debates that may pop up between whether the proper time period for looking at analogous gun control laws is at 1791 when the Second Amendment was ratified, which is probably almost certainly the correct answer, or a more theoretical scholarly argument that the proper time period is 1868. Why is it 1868, Mark? What the heck is this about? Well, 1868 is the years after the Civil War, where the American people adopted the 13th, 14th, and 15th Amendment, specifically the 14th Amendment, because it's the 14th Amendment is the mechanism whereby the courts in America, including the Supreme Court, takes the Bill of Rights, including the Second Amendment, and incorporates and applies them to prevent state and local towns, villages from violating the Second Amendment right. Because remember, when in 1791, the Second Amendment only prevented the federal government from infringing on the right to keep and bear arms. And in 1868, basically the Bill of Rights, the Second Amendment, was effectively incorporated and applied against the states. So there's a historical debate whether or not the proper time period to look at what people intended is 1791 or 1868. But again, we're going to talk about that in more detail in a different video, just so you're aware of the topic. But the judge does flag that he's not sure whether or not the proper period is 1791 to look at for historical analogs, or is it 1868 to look at for historical analogs. But he says it doesn't matter because just like the Supreme Court said, for the purposes of these carriage cases, the law is the same, meaning there are basically no real historical analogs on the restrictions on the right to carry in any way that would be material to this. So the court says it doesn't matter what time period I look at, although I do want to flag that he does mention that there could be a debate about which is the relevant time period, but he says for the purposes of this case, the answer is going to be the same, which is there's not really any historical analogies that the government of New York can use to uphold these gun control laws. So let's go through the specific gun control laws that New York is trying to justify, that they enacted through statute and they're trying to say is consistent with the Second Amendment right to keep and bear arms, which it almost certainly is not, as this court found. So let's start. First of all, New York passed laws that says before you can conceal carry a gun in New York under the Second Amendment, you have to have good moral character. The problem with good moral character is how is it understood and defined? The U.S. Supreme Court basically said that if there's objective criteria here, black and white, no discretion, then, that assessment may be fine. So what did New York pass exactly involving good moral character? So what they said about good moral character is this. They specifically said that no license shall be issued or renewed except for an applicant of good moral character, which shall mean having essential character, temperament, and judgment necessary to use the weapon entrusted to the applicant only in a manner that does not endanger yourself, or I should say oneself or others. The court immediately jumped on this and said, this is an absurd standard. Why is that? Look at the critical language of the statute at the very end. It says, the judgment, you and I being allowed to carry in New York, would have to show the judgment to use the weapon entrusted to us only only in a manner that does not endanger oneself or others. Now, the court says this is an absurd law. It can't work. And why is that? Because the whole point of the right to keep and bear arms is self-defense. So the judge says that there's no exception here for self-defense. Specifically, the whole notion of being able to carry a gun is so that you can use violence if you need to, or threaten violence if you need to, against a threat. And this law that was rushed through by New York doesn't account for that. And the judge said specifically that the fact that the definition of good moral character fails to expressly contain the qualifying phrase other than self-defense mean it fails. Again, New York wrote a law that says that, you cannot use guns in self-defense to harm others or yourself. But of course, the whole nature of self-defense is, again, you get to use deadly force in appropriate occasions to harm the bad guy. And the court immediately jumped on this and says, you don't even have an exception for harming the bad guy, New York. This cannot possibly withstand constitutional or legal scrutiny. So the judge right off the bat says, this law is not going to fly. That's the first thing. Does that sound like a win to New York when you have a federal judge saying this can't fly? Now, the second point, and this is very important, if you read the article I published in the Harvard Journal of Law and Public Policy just last week, where I really lay out how judges should apply Bruen going forward in a way, frankly, in my opinion, I think it's very favorable for gun owners. And one day we'll see if courts start to cite to my scholarship. If they don't cite to it, I don't care, as long as they, frankly, review it and understand it and realize it's the right way of going, because I think it is. But anyway, here's the key point. The judge said that this good moral character requirement basically is unconstitutional for another reason, and that is because it allows the police departments that approve these concealed carry permits to exercise improperly a different type of discretion than before, but the same kind of discretion that the Supreme Court says you can't do. Remember the way it worked. In NYSERPA versus Bruen, the Supreme Court says that these government officials were able to exercise their discretion to determine that you could carry a gun and I could not carry a gun and Bob could carry a gun and Sally could not carry a gun, and that discretion as to who deserved to carry a gun, who had proper cause to carry a gun, the Supreme Court said that's absurd. That's not how constitutional rights work. We all have the right to carry a gun as a general matter until you demonstrate yourself irresponsible with it. That's what the Supreme Court basically said. So what New York did is they said, okay, well, we're not going to have a proper cause discretionary requirement anymore. What we're now going to do is have a new standard of good moral character, and we're going to allow our police officers to determine whether or not you and I and Sally and Bob have good moral character, which is basically a different way of using the discretion of the government to determine who gets to carry and who doesn't. And this federal court said, this is the same problem as we saw in NYSERPA versus Bruen, and you cannot give this kind of discretion to law enforcement to determine who gets to carry and who doesn't, and whether or not it's about whether they have proper cause or whether they're good moral character. It doesn't matter. This is unconstitutional under the Second Amendment, and that's what the court said in this case. Now, the court did say it's perfectly fine to do background checks. So the court said rather than having open-ended discretion that cops can make decisions about you on, it's more appropriate if they do fingerprinting to make sure that you're a law-abiding background check, maybe a mental health records check, which we can talk about that later, what that means, and basic training in firearms and whatnot. He said that's objective, and it doesn't really, once you do those things, you get to carry a gun. And the court said that would be fine because they're objective, and no police officer can make this discretionary decision about good or bad, whether you got good character, more bad character, whatever it is. And the court said that, again, it has to be objective, which is exactly what I write about in the Harvard Journal of Law and Public Policy. All this has to be objective. It cannot be discretionary in any respect regarding the government's decision whether you get to carry a gun or not in New York or otherwise. So the next part of the court decision discusses the challenge to three aspects of New York's new gun control law. One is training, one is in-person meetings with the police officer, and one is for references that you need to go get, and one is social media. So we'll take one at a time. Let's start with the social media disclosure. Well, the court basically said that he thinks the social media disclosure is unconstitutional for several reasons. This is very important because I know a lot of the anti-gun states want to be able to review everyone's social media, and the court says that's not going to fly for several reasons, basically 4 or 5 reasons, and I'll hit the highlights. The first one the court says is he actually cites to American history and points out that going all the way back to the Founding Fathers, there was a tradition, and this is Supreme Court precedent, by the way, of anonymous pamphleteers. So if you look at the Federalist Papers, for example, it's not signed Alexander Hamilton or John Jay or any of that. It's signed like Publius or Cato or some other Greek name, but it was an anonymous name, which is not unusual for people to use on social media accounts. So the court says, well, you can't force people to reveal themselves as on their anonymous social media accounts any more than you could force at the founding era to force, anonymous pamphleteers to disclose who they were so they could exercise a right to keep and bear arms or any other constitutional right. So the court made that observation. The second observation the court made is, what the heck are police officers going to be looking for? Again, remember the rule that I think that the Bruin case set down that I talk about in my article that says that these standards have to be objective. Black or white, yes or no, green or red, lights on, lights off, objective. No squishy discretion like, well, maybe yes, maybe no. No, that's no good under the Nyserpa versus Bruin decision by the Supreme Court. And this court said, yeah, we agree. That's true. Okay. Now, what the court goes on to say is that what exactly are you asking the police officers to be looking for if they go through 3 years of your social media post? Like, what are they supposed to find? So they find some nasty comment you made about Joe Biden and what? Was that proof? Nothing. And the only way to derive conclusions that means you're not have good moral character means that they're now exercising their discretion as to what runs afoul of good moral character and what doesn't, which is not acceptable because, again, these standards have to be objective, not subjective. That's not Mark, although I write about it. It's the Supreme Court standard itself. The third related point the judge made on social media accounts is this, again, likely violates the First Amendment. Why is that? Because the First Amendment right to free speech, you now have to basically think about censoring yourself in the social media in order to exercise your Second Amendment rights. This trade-off between constitutional rights, according to the U.S. Supreme Court repeatedly, is that we don't force you to give up one set of constitutional rights to exercise another. And that's what the court said here, that forcing gun owners to have to disclose their social media accounts and what they say about politicians and others so they can exercise their right to keep and bear arms, meaning basically sacrifice their First Amendment rights to exercise their Second Amendment rights or give up their Second Amendment rights to exercise their First Amendment rights. The court said that's just not acceptable under Supreme Court precedent or how we interpret the Constitution, so that's going to be a no-go. So the next point the judge makes about social media accounts is that it violates the Fifth Amendment right against self-incrimination. We all have heard the phrase, take the fifth. Now, what does that mean? Basically, that's very good advice in almost all instances when there's any issue involving potential criminality. And taking the fifth means you are invoking your right not to incriminate yourself under the Fifth Amendment to the Constitution. So what the court here says is that, forcing people to turn over all the statements they've ever made and all the information they've ever exchanged in social media accounts runs the risk that you may be forcing them to incriminate themselves if they engage in some criminal behavior or something like that. And again, he's like, that's just not acceptable because you're forcing the people, the gun owners, to turn over potentially incriminating evidence to the government, and they have a Fifth Amendment right not to do so. And yet again, as we mentioned, you do not force people to give up their Fifth Amendment rights to exercise their Second Amendment rights or their Second Amendment rights to get the benefit of their Fifth Amendment rights. So that's what the court said. So basically the court said there's no way these social media account reviews should withstand constitutional scrutiny, and I think that's a good thing. The next part of the court's decision addressed whether or not New York could require people to show up for a face-to-face meeting with the police and whether or not they could be required to get 4 references saying they're good people. And the court said at this point, he didn't feel like he had enough evidence. The record was not sufficiently developed for him to reach a conclusion on this. He thought it required some factual analysis, and there weren't enough facts in the record. So he basically said, for now, I'm not going to say anything about an in-person meeting. It seems like having an in-person meeting with police is probably okay. He also said that getting 4 references doesn't appear to be a particularly difficult burden, so that's probably okay. Although I would question that dramatically because, again, even though he did not sign off on this, he said, I don't think the plaintiffs have done enough to show that getting 4 references violates the Second Amendment. But I think that's something that's very subject to challenge because, again, I view it as kind of like a little bit of a tax. And what, a lot of people, especially in places like New York and California, might not want to get involved with anything touching on guns. So even though they think you're a great person, they may not want to sign a form saying that you should get a gun, right? Because they just might not like it politically or whatever. And again, we don't asked for 4 references to exercise our other rights, including the right to post on Twitter, let's say. So I think that 4 reference requirements. And by the way, not everyone has 4 people close enough. I mean, how many people maybe live in the woods or by themselves or they're loners? they're legally allowed to have the right to keep and bear arms, even though they don't have friends, right? And there's no requirement in America that you have to be social and have lots of friends and close friends and all this sort of thing. So it seems like a little bit of a stretch that this is a requirement. But again, the court right now said he wasn't going to rule on that. He just said, well, it may be okay. It seems like it's okay here. But he really said that that would require further analysis down the road, which I think is probably true. So the next point the judge made was about training requirements. And again, he said that at this point, there's not enough evidence. We're not sure what the training requirements are going to be. And this plaintiff, I think, did not actually need to engage in them because he had already done it. He already had his carry license, so he wasn't going to be subject to the new rules anyway. And I think that probably was a big factor in why they concluded he didn't have standing. But the judge basically said, yes, some training requirements is probably okay, but they can be too onerous, which is what the Supreme Court said as well, that some basic training may be acceptable to require someone to have before they carry a gun in public. But if they're too onerous or take too long, then that may run afoul of the Second Amendment. Okay, so the next major victory in support of gun rights, as I see it, is how the court literally scoffed entirely at the approach that New York State took when it came to sensitive places, gun-free zones. Basically, the federal court said, New York, you guys are insane. The way you've done in sensitive places here is totally backwards. The way you've defined sensitive places, gun-free zones, is essentially the whole state is a gun-free zone sensitive place. And that's not what the Supreme Court said you can do. In fact, the Supreme Court specifically says what you're doing in New York, you're not allowed to do, and the judge called them out on it. Specifically, and we've talked about this before on this channel, the court reminded everyone that, as the U.S. Supreme Court said, there's really only three, maybe 3.5 types of sensitive places, gun-free zones that are allowed in American life. Those are, you might be able to you don't have to, but you could probably legally ban guns in government buildings, in courthouses, in legislative chambers like Congress or the state legislature, and maybe in public schools, although that could be a distinction between allowing students to carry versus allowing faculty members to carry based on the historical precedents. And basically, this court said, look, that's your examples, that's your sample set of sensitive places, gun-free zones in New York, and you literally went out there and created a list of hundreds, if not thousands, of sensitive places all across New York, and this is not acceptable. In fact, what's very interesting is that the court specifically said that New York, the way you've gone about doing it is essentially saying that people show up and congregate in these places, and there's generally police around. He says, but the Supreme Court specifically told you you're not allowed to do that when they wrote the NYSERPA versus Bruin case. The Judge Thomas's opinion specifically says, look, you can't just say, well, people show up in Times Square and there's generally law enforcement generally around there, therefore we can make it a gun-free zone. The Supreme Court specifically says you cannot do that. In fact, they actually said that one thing New York's not allowed to do is declare Manhattan a gun-free zone. Manhattan being the biggest borough of New York City's 5 boroughs. So this judge says, hey, New York, this ain't going to fly. This is no good. Your definition of sensitive places is clearly antithetical to what the Supreme Court said in NYSERPA versus Bruin. And to make it even worse, he said, you got no historical analogies to show that any of this stuff could be deemed sensitive places because, again, Times Square is not a government building. Times Square is not a school. Times Square is not a courthouse. Times Square is not a legislative chamber like the U.S. Capitol. It's just not. So there's no basis historically in 1791 to show that this can be done. And since the burden of proof is on, again, the government, which is what this judge said and the Supreme Court said, the government has to come forth and say, oh, there's a bunch of examples at the time of our founding where Times Square or something like Times Square was a gun-free zone. But we know that's not true, simply not true, for no other reason than what happened at the Boston Massacre. Remember, Boston was basically the second largest city in the colonies at the time of the American Revolution. And during the Boston Massacre, which, as you know, Bostonians, there was basically a fight or a dispute between Bostonians and the British Redcoats, and the Redcoats opened fire and killed several Bostonians. There was a big trial associated with the Boston Massacre, where the British officers and the British soldiers were put on trial for murder of the Bostonians. And in that case, John Adams, one of our greatest founding fathers, representing the British, said, look, we concede that in America, the Bostonians in the heart of Boston were allowed to carry arms in public. because that's how it works in America. So somehow to say that Times Square, which is the analogous place to Boston, I think it's State Street or whatever it is, for downtown Boston. So if you could carry guns in downtown Boston and in the second largest city in the country in 1791, you certainly should be allowed and will be allowed, in my view, to be able to carry guns in Times Square soon enough when the next court strikes it down, because this court would have struck it down because he said these are not sensitive locations. You can't ban these guns in these places. New York State, it's not allowed under the Second Amendment or the Supreme Court's precedents. Now, the last part of this opinion that I want to emphasize is the notion of restricted locations that New York enacted. Now, this is a little bit different than sensitive places, although it's very similar. Sensitive places are, they just said no one's allowed to carry a gun in these sensitive places, whether you have a permit or not. And if you do, it's a Class E felony, I believe. So they're going to turn you into a felon if you carry a gun that you were allowed to carry under the Second Amendment and under your concealed carry license. But if you walk into the wrong place, you walk into a theater, you walk into a homeless shelter, whatnot, you walk into Times Square, you lose your gun rights. In fact, you become a felon and lose your gun rights forever because now you're a felon. Okay, now there's another thing that New York did was very tricky. They call it restricted places. This involves private property versus public property. Specifically, they say that the presumption going forward is even if you have a concealed carry permit, you're not allowed to bring it into a person's home. You're not allowed to bring it into a person's apartment. You're not allowed to bring it into a store. You're not allowed to bring it into a department store or a grocer or anywhere that involves private property without the express permission of the owner. And the owner has to post a sign up that says guns are allowed here. And if the owner of that private property does not post the sign or does not explicitly tell you you're allowed in, then you are a felon. Now, the court here, the federal court here says to New York, no. Again, where is your historical analogy to this, New York State? There is no historical analogy to saying that the presumption or default position is that Americans have no right to walk on private property with firearms. Okay, so the judge said that this is not going to fly either. Again, because this case lacks standing with the plaintiffs, the judge gave this decision in what's known as dicta, but he basically says that's not how the law works. This is not going to be what withstand constitutional scrutiny once there's a real plaintiff in here. So again, the judge basically said that the default position in American life has always been you're allowed to carry a gun anywhere you want to carry a gun, unless, of course, you're banned from doing it. So if someone says, don't come onto my property with a gun, that's one thing, but the presumption cannot be the government tells everyone that owns private property, no one is allowed to bring a gun on your private property unless you post a sign that says guns are allowed. That's not how the American government works. That's not how the Constitution works. And that's not what the Supreme Court said in NYSERPA versus Bruin. So again, this judge seems willing to strike down all those types of laws once there's an adequate plaintiff with standing to be able to challenge it, which I don't think will be that hard to find. So the last point I want to make here, which I think is interesting, is the court went on and basically said that the plaintiffs would likely win this case if they had standing, and he laid out why, which is huge news for the gun-owning community, contrary to the PR myths propagated by the anti-gun community and the New York politicians. Then he goes on to say that certainly if the plaintiffs had standing, they would be, irreparably harmed because they would be committing crimes if they violate, if they try to follow the Constitution and not follow New York gun law, they will risk being arrested and going to jail, and that's irreparable harm. But the other thing that I want to mention that the court said that is very interesting is the court actually picks up on a line of discussion that Justice Alito talked about in the Bruin case, and that involves people that need firearms to protect themselves. The judge talks about senior citizens. He talks about disabled people. He talks about people who work late at night. And he literally quotes Justice Alito, who, by the way, Justice Alito on the U.S. Supreme Court is very savvy when it comes to New York geography because he was on the Third Circuit Court of Appeals before he was on the U.S. Supreme Court. And where is the Third Circuit Court of Appeals? It's in New Jersey. So Justice Alito was quite familiar with the New York, New Jersey world and how it really worked because he was a prominent lawyer there and then became a prominent federal judge before ultimately being elevated to the U.S. Supreme Court. So when Sam Alito talks about these kinds of realities of how it works in New York, meaning people taking a subway home late at night. By the way, subways are deemed sensitive places, so you can no longer bring a gun on the subway until that law struck down, which looks like it probably will be at some point soon. So Sam Alito talks about how people need guns. They, especially a lot of people who work late at nights who work to clean these fancy office buildings, for example, they have to leave at like like 2 in the morning, because the way it works in New York City is you have these fancy office buildings. You've seen them on TV, outside Rockefeller Center and all that stuff. You've seen all this stuff. So what happens, of course, during the day, people like lawyers and bankers and professionals work 9 to 5 or 9 to 8, whatever it is, and then they go home. And guess what happens next? At night, the cleaning staff comes at like 6 or 7 or 8 o'clock at night, and they work until 2 or 3 in the morning cleaning the office tower for the next day. So you have all these people that are working for modest wages, shall we say. I don't think they're getting paid like Wall Street bankers. So you have these people working at modest wages. They take a subway to Manhattan, often from the outer boroughs. They work late at night, from, again, their shifts are like 6 to 2 in the morning or 8 to 4 in the morning. They take a subway in. They do their job cleaning these office towers for the professionals that work during the day, and then they walk back to the subway, and they get on the subway, and they go back usually to the outer boroughs of the Bronx or Queens or Brooklyn or whatnot. And then what happens when they get off the subway on the other end, they have to walk home at 2 in the morning or 3 in the morning or whatever it is. And Sam Alito in Nysurpa versus Bruin said, this is absurd that you're going to deny these kinds of people the opportunity to have a gun when they are on the subway, when they get off the subway to go to their jobs, when they get off the subway to go to their homes after working late at night. This is crazy talk, and it's not allowed under our Second Amendment right to keep and bear arms. And this judge specifically talked about Justice Alito's analysis when it came to protecting the people that work late at night, the disabled people, the handicapped people, the people that are not physically capable of fighting off, evil doers and violent threats without a firearm. And I think that's quite telling of where this federal judge's head is at. And I think this is the first of many decisions. Now, it's true, unfortunately, that Gun Owners of America and Mr. Anichuk lost this case because of a lack of standing, but that can be fixed either by another plaintiff or in other cases. So this, and by the way, I do think the standing analysis the judge applied is probably wrong. There probably was standing here, but we're not going to talk about that on this video. And again, the point is whether they come back and assert standing properly or whether they get another plaintiff or someone else gets a different plaintiff or a set of plaintiffs, it is pretty clear that these New York laws that New York was all excited about, woo, look at all these great new anti-gun laws, and we won this case based on standing, a technicality, it's pretty clear that a lot of these laws are probably going to be thrown into the trash bin of history. And in my view, that cannot happen soon enough. Okay, folks, I hope you learned something here today. I know it was a little bit longer, but we had a lot to cover. Very important decisions, a lot of moving stuff here. I hope you learned something here at the Four Boxes Diner. If you haven't subscribed, please do so. We're working hard to build our subscriber base. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.